Breaking news. Earlier this week, Trump administration asked Supreme Court to resume deportation of nearly 200 Venezuelan migrants. Earlier today, Supreme Court blocks Trump from restarting Alien Enemies Act deportations. Nice. There you go. Court once again angry at its role being taken. It's being replaced. Pretty funny stuff. What was the vote? 7-2. You know the two. You're aware of the two. The decision is a significant loss for Trump, who wants to use the law to speed deportations and avoid the kind of review normally required before removing people from the country. But the decision is also temporary, and the underlying legal fight over the president's invocation has continued simultaneously in multiple federal courts across the country. The justices sent the case back to an appeals court. This does make me feel a little bit better about what the likelihood of the national injunction thing is going to be at the end of June. You know, if the Supreme Court is continuing to put its foot down in this manner, it does seem a little bit more likely they're going to rule against the Trump administration on the question of whether or not judges should be allowed to do anything. Alito and Thomas, of course, the dissenters. The court noted the Trump administration has represented that it is unable to provide for the return of an individual deported in error to a prison in El Salvador. Given that, the court said, the detainees' interests at stake are accordingly particularly weighty. The court added that the way the Trump administration was handling the removals did not, quote, pass mustard. Mustard! Sorry, that's a deep-cut hip-hop reference that some of you people might be too white to understand. Pardon me. It's called code switching, liberal. Specifically, the justices pointed to notice of only 24 hours that was devoid of information about how to exercise due process rights to contest that removal. The Supreme Court sent the case back to the New Orleans-based 5th U.S. Circuit Court of Appeals for further review, saying in its order that the appeals court erred in dismissing the detainee's case. Huh. Not bad. Actually, not bad, you know, considering the circumstances. Certainly Trump is mad about it. The Supreme Court is being played by the radical left losers who have no support, the public hates them, and their only hope is the intimidation of the court itself. Wait. We can't let that happen to our country. The radical left is intimidating the Supreme Court? Okay. I'm sure that'll incline them positively towards him, you know. They're going to love that crap. You mean the Supreme Court built by Trump? It is very funny that Trump's appointees have not been the hardline lunatics that he wanted them to be. You know? It is very funny. Like, they could have been. He could have picked them. But in all likelihood, like, the picks back then were moderated more by the understanding that we were going to have more or less a democracy. You know? Thomas and Alito were Bush appointees. The Chad neoconservative fascists versus the virgin neo-fascist rhinos. I don't know, man. It's a weird flip. It's a big deal, folks. They're gonna have to do something. The whole... Okay. It's pretty obvious that the goal of the Trump administration is to just flat out end democracy, right? Like, you'd have to be an idiot to disagree with that. Everything they've done, every step they've taken, the messaging they engage in, all of their rhetoric, all of it points to that. They're basically like, it's the most consistent thing they believe, ending democracy. It's the most directed position. So in order for them to do that, they need to do one of two things. Upend the entire judiciary. This would be an enormous process. We're talking like thousands of arrests, trials, show trials accusing judges of being left partisans, of being traitors, whatever else. It would be very difficult to do. Or via the Supreme Court, ending federal injunctions altogether. Alternatively, they could persist with the federal injunctions and just ignore them, but that's not really workable long term. What dictator wants to spend their entire dictatorship constrained by a bunch of legal rules that, like, nominally have power but effectively don't? Every day you wake up to 50 headlines from judges talking about how, like, you're breaking the law. Like, you want to put them all in jail, but you kind of can't, because like you don't really have the inertia, you don't have the legal pretext. It would look too bad for you to do. And there are limits on what they can do. Keep in mind that even in more dictatorial countries like, say, Hungary, right, Viktor Orban, there are limits. You can't just snap your fingers and go like, actually, I'm arresting everyone who stands against me. Because, like, believe it or not, even when things are this obvious, even when things are this, like, mask off, there is a stupid majority of tens, maybe hundreds of millions of people who really don't see the writing on the wall. A lot of them who support Trump and would be alarmed by behavior like that. You understand? So the fact that the Supreme Court isn't playing ball with this is, I mean, a little unexpected. Again, they do have a 6-3 majority. I don't understand why they're not. Like, every other politician has been bought. Are they just more susceptible to this sort of thing? Are judges too haughty? Are they too, like, egotistical? Are they too concerned with the eradication of the rules they spent their lives studying that they won't, like, erase them? It might just be greed on their part, or ego. The idea that, like, you know, I've spent my entire life studying the law. I'm literally a Supreme Court justice. Why should I enable these morons on my side of the aisle and give them power by relinquishing it myself and invalidating the field that I've spent my life studying? I understand it from, like, an egotistical perspective. I understand it. It's just, you know, it's wild that the future of the country kind of, to a large extent, hinges on the ego of these Trump appointed justices. It's very weird. And it does make it does seem pretty clear following this, like, why on earth would the court enable an end to the concept of a federal injunction when they themselves are enabling the federal injunctions? Like, the court is basically signaling not just that they oppose Trump on this, but that they oppose Trump on the merits of the underlying argument he's trying to make, an ending to to federal injunctions. I mean, that's what they're essentially doing through this. If we don't get the Enabling Act, that would be good. Yep. Here, hold on. Give me a relevant snippet. Thank you, Twitter, source of all good journalism, I'm told.
Justice Kagan, opinions and judgments here. Did I understand you correctly to tell Justice Kagan that the government wanted to reserve its right to maybe not follow a Second Circuit precedent, say, in New York, because you might disagree with the opinion?
Our general practice is to respect those precedents, but there are circumstances when it is not a categorical practice. It is, and that is not
this administration's practice or the longstanding practice of the federal government. And I'm not talking about in the Fourth Circuit, are you going to respect a Second Circuit? I'm talking about within the Second Circuit. And can you say, is that this administration's practice or a longstanding one?
As I understand it, longstanding policy of the Department of Justice. Yes, that we generally, as it was phrased to me, generally respect circuit precedent, but not necessarily in every case. And some examples might be a situation where we're litigating to try and get that circuit precedent overruled and so forth.
Well, okay, so I'm not talking about a situation in which, you know, the Second Circuit has a case from 1955 and you think it's time for it to be challenged. That's not what I'm talking about. I'm talking about in this kind of situation. I'm talking about this week, the Second Circuit holds that the executive order is unconstitutional, and then what do you do the next day or the next week?
Generally, we follow those.
So you're still saying generally?
Yes.
And you still think that it's generally the policy, longstanding policy of the federal government to take that approach?
That is my understanding.
Okay, so, but it sounds to me like you accept a Cooper versus Aaron kind of situation for the Supreme Court, but not for, say, the Second Circuit. Like where you would respect the
that pause.
opinions and the judgments of the Supreme Court, and you're saying you would respect the judgment, but not necessarily the opinion of a lower court.
And again, I think in the vast majority of instances, our practice has been to respect the opinion as well, in the circuits as well, but my understanding is that has not been a categorical practice in the way respect for the precedents and the judgments of the Supreme Court has been.
So you're not hedging at all with respect to the precedent of this court?
That is correct. I believe the quotation from our application directly addresses that, and we stand by that completely.
Okay.
They're going to replace Sauer at some point, man. He's going to be blamed for a lot of unfavorable rulings, and his arguments in favor of the administration are not like that good. There have to be more talented people in the administration who could argue for like the end of the republic. The ruling also explicitly stated migrants have a Fifth Amendment right to due process, which is a huge win because other judges can refer to it. Yeah, no kidding. We need to actually read the, hold on one second. Let me try to find the relevant snippet from it, because that's, it's not just a procedural thing. Like it's a, it's precedent established that undermines the entire logic of the Alien Enemies Act invocation. You know, like it goes beyond just a protection of these migrants. And now, like, the court's essentially saying, well, no, you have to, like, on an individual merit case, you have to argue these people need to be given the opportunity to defend themselves. I want to get like that snippet. I see Fifth Circuit, not Fifth Amendment. The government does not contest before this court the applicant's description of the notice afforded to AA detainees in the Northern District of Texas, nor the assertion that the government was poised to carry out removals imminently. The government has represented elsewhere that it is unable to provide for the return of Abrigo Garcia, where it is alleged the detainees face indefinite detention. See application to injunction. The detainees' interests at stake are accordingly particularly weighty. Under these circumstances, notice roughly 24 hours before removal, devoid of information about how to exercise due process rights, contest that removal surely does not pass muster. Yeah, it seems like it's a rejection of the Alien Enemies Act at its core. Again, not a lawyer. Hopefully somebody, yeah, go to next post directly from here. Thank you. I know what the arrow does. I'm not a lawyer. I mean, if somebody would like to weigh in on this, perhaps with a little more knowledge than me, but it seems like in this statement, the court is essentially saying, like, well, the problem with removing people via the Alien Enemies Act is that they're not getting due process, which is the whole point of the Alien Enemies Act. It seems like the court isn't refuting the invocation of the act as a pretext for justifying the removal, but not allowing it with regard to its revocation of due process. Am I correct in saying that? They're essentially saying, like, you can't have it, but you can't have both halves of it? Because if that's the case, that's absolutely massive. Because the problem with the Alien Enemies Act, in my humble opinion, pardon me, you know, wasn't so much the pretext for deportations. I expected the government to deport people. For me, the real issue was the no due process thing. That's the thing I find scary, you know? Like, is it okay, like, you know, they're deporting people. That's bad, but if it's being done through the due process of law, at the very least, like, it's liberal? Yeah. Huge. Not exactly. They're objecting to the way it was carried out. In the original use of the Alien Enemies Act, they still had a hearing to determine if the individuals were subject to the act. Okay, so they're saying that the Trump administration has failed to even meet the standards allowed by the act. So they're not necessarily, well they are arguing for a need to exercise due process, but what they're saying is that the Trump administration is falling below even this very low bar for the provision of due process. They're saying, like even by the standards of the Alien Enemies Act, which we're not contesting your invocation of, even by the standards of this act, you are not meeting the bar. Am I correct in saying that? Yeah, the case isn't about the legality of the Alien Enemies Act, so that wouldn't be appropriate for them to rule on, really, I guess. Correct, even Japanese Americans had the opportunity to see a judge and contest whether they fell under the class of people to be interned. Okay. Effectively, by my reading, it's a procedural objection. Right, it's a procedural objection, but it's a procedural objection to the procedure that we want, I guess. Because, like, they're not deporting members of Tren de Aragua. Remember, that's the invocation of the Alien Enemies Act. That's the argument, that they're deporting members of Tren de Aragua. So if the due process they're allowed is a day in court to determine whether or not they actually are a member of Tren de Aragua, that, like, I guess the difference here being, like, with regard to the Alien Enemies Act or like Japanese internment, the category of people being interned, for one, we were actually at war with Japan, right? But they were interning Japanese nationals, which, if you were proven to be a Japanese national, I guess, like, there you go, you're sent to the detention facilities, which was bad, to be clear. But in this case, the targeted class of people, members of Tren de Aragua, like, the people being sent to El Salvador aren't even members. Oh, it wasn't just Japanese nationals, it was just anyone with Japanese heritage? Okay, fair point. But I get the point I'm making is that the class of people they're targeting with the Alien Enemies Act is much more ephemeral. It's much more abstract, and it's more difficult to prove, which means we're going to have to hear court arguments from the DOJ where they show up and they're like, here's our evidence that, you know, Abrego Garcia is a member of Tren de Aragua. Do you see these tattoos on his knuckles? You get me? Yeah, I want to hear the Trump administration argue in court why a person's autism awareness tattoo makes them a member of Tren de Aragua. I want that shit entered into the record. Look, the more the Supreme Court forces the Trump administration to litigate and to explain their arguments, the better it is for us, because they are stupid. The more they are forced to go out there and bluster and argue, every time they show up in court, they get schooled by the judge. You know, like they don't come in with any information, because the real like justification for these deportations is like giggling psychopath DHS members who are like grabbing anyone they can to meet a quota that's being passed down from the federal government. Like they don't have arguments. They're probably not even keeping paperwork on most of these people. In saying that SCOTUS has been picking up the mantle, weren't we expecting them to be goose-stepping? Yeah, I was, but you know, look, the world's complicated. And you know what? Given how much has gone wrong for this country over the past while now, I'll take a couple of soft pitches when they come in. You know, I'm not going to bitch about them. Oh, that was supposed to be a curveball? I'm not going to complain. God damn, man. Can't believe we're rooting for the classical liberals. We're not. You don't need to draw the lines like that. Even the right-leaning members of the court, with the exception of Thomas and Alito, have a bias towards proceduralism. And MAGA's method of governance is anti-procedural, as fascists often are. You don't need to make any broader ideological claims about siding with classical liberals or anything like that.